distinguished expert joining us today. Our next session on the topic, patent landscape, will shed light on the critical intersection of intellectual property and innovation. Allow me to introduce our esteemed guest speaker. It is an honor and a privilege to introduce our esteemed speaker for the second session, Ms. Kalyani Ahir ma'am, a visionary leader and a trailblazer in the field of intellectual property rights and innovation. Ms. Kalyani Ahir is the CEO of Sinolect Innovation and currently spearheads the IPR cell at Savitribai Phule Pune University under the SPPU DIC. In this role, she is dedicated to raising awareness about intellectual property rights and fostering innovation from concept to commercialization across departments, students, and faculty members within the university and its affiliated colleges. Her contribution extends far beyond a single institution. She actively drives innovation programs across Maharashtra, empowering startups, technology, business incubators, and entrepreneurs. She has been appointed as an IP expert on the Innovation Incubation Council, that is IIC, for esteemed educational institutions like Savitribai Phule University, Vidya Pratishthan Baramati, SVPM College of Pharmacy and Engineering Baramati, and Modern College of Arts and Commerce, Pune. Ms. Kalyani Ahir brings a wealth of expertise in patent drafting, filing, and prosecution for Indian, US, and European patents, and she is deeply involved in the licensing and commercialization of intellectual property rights. As a member of the World Entrepreneurship Cafe, a global community for fostering entrepreneurship, she continues to make an indelible mark on innovation and a technology transfer. With her vast experience, unwavering dedication, and a profound impact on the innovation ecosystem, we are truly privileged to have her today for this session. Please join me in welcoming the exceptional Ms. Kalyani Ahir Madam to enlighten us with her insights and expertise. Over to you, ma'am.
Yes, sir. Thank you, sir, for such an wonderful introduction. It is really my privilege to having been invited and speak on this forum. And it is my really nice fortune to be amongst all of you all, such great minds and such enthusiasm that you have showed towards innovation and entrepreneurship. We've been in touch with all these activities since long. So really nice, and congratulations to all the team to organize this session. This is 5 days long session. Yeah. So we've got all the faculties only, right? As an audience?
Yes, madam.
Okay. Yes. So, okay. I'll just share my PPT. But before I share my PPT, I would just like to know from you all, what is the concept about IPR that you all hold? What is IPR according to you? The audience? If you think about IPR, you think about intellectual property right, what is one thing that actually comes into your mind?
Ma'am, patent.
Okay. Anyone else?
Hello, ma'am. Am I audible?
Yes, ma'am, you're audible.
An idea or invention that comes under the intellectual property, and when we registered under our IPR, that means intellectual property right, and also the secret production method that is also come under the IPR. That means any right that is protecting our asset, or that we have come with any kind of brand or trade name that comes under the IPR.
IPR domain. Wonderful. So this is the background you've got. Okay. Just to explain these things better or in a more efficient manner, because we all should know or understand, of course, you all know, but just to make it more empathetic, I would like to tell you all two stories. Okay, just justify or put more weightage on what exactly why IPR is important. Okay, so one story is a hypothetical story. I hope everyone is in. Y'all can hear me.
Yes,
Yes,
ma'am.
ma'am.
I'm audible, no? Okay, okay. Just in case my voice goes or if I'm not audible, just let me know over chats or over a thing so that because I won't be able to. Yeah. So I'll tell you all two stories. So first is a hypothetical story and second is a true story. Okay. So hypothetical story is there was a village. In that village, there was a king who had given a task to the woodcutter saying that whoever would cut wood and come and give it to the king will reward the woodcutter according to his wood. He'll measure the wood and he'll give the amount of wages which is decided for the day as per the weight of the wood. And during that time, there were not much sophisticated instrument like we have a lot of sophisticated instruments to cut big logs of wood and all that, but that time they did not had much sophisticated instruments. So what they used to do is they used to kind of have they used to tailor made certain instruments so that it will be easier for them to cut those woods. So the amount of work which was happening in cutting the wood and the amount of wages they were getting was not really matching. So there was one woodcutter, he was not very happy with it. He was not very happy with it. So he said, ki, okay, let me do something. Let me devise something which will make my work easier. And since every one of us are engineer, we know what will make our work easier? Any machine, right? Machine will make our work easier. So what he did, he devised something called as an axe. So not exactly an axe, but something like an axe, which had a handle to hold and which had a sharp edge. Okay, and then he could get more amount of wood as compared to the other people in their so he was
Hello.
getting more amount of food. Yeah, he was getting more amount of food as compared to the other people in this. Yeah, am I audible?
Yes, you're audible now. Now, ma'am, there was an
Yes.
echo from.
Yes, yes, there was
So
some
now it's
echo which was happening.
yes.
Yeah. So, so they said he prepared something called as an axe. So axe would make their work easier. At the same time, he was getting more amount of wood as compared to the other people in his workplace or in his faculties that way. And then people started asking him, how did you make this instrument? How did you make this instrument? When did you make this instrument? Please give it to me. But he was scared. Why was he scared? What if someone copies my instrument? What if someone steals his instrument and says it belongs to me? So he was scared. So he did not disclose this invention to anyone. And he did not even disclose his invention to the king also. Okay. And then one fine day he died. One fine day he died. So what people did is they kind of identified, they got his instrument, identified what his instrument was all about, and then they back engineered it and they made a much better instrument as compared to what he had made. Okay, now this was one story where people wanted the invention, they were in really need of it, and someone really catered to that need of the invention. to making their work easier. It's as simple as making the work easier. So the problem was solved in a much efficient manner. But the only hurdle which he had was he was scared. What if people copies my invention? What if people steals it? What if people steals and says it belongs to them? So I will not have any monopoly of the invention, right? All of us also have the same feeling, more or less, sometime in our research careers. What if someone steals my invention? What if someone who's working with me takes away the inventions? Okay, so all of us can relate to the problem that he was really facing. And because of this fear, he could not disclose his invention to anyone, and then he died. And then people back into the invention, they made a much better instrument as compared to what he had. It's a very hypothetical story, but it has a very good lessons to be taken back with. So they back engineered and they made a much better instrument as compared to what he had made. So there was one story. So he was not of really much benefit basically. So he got an instrument. He did not get much benefit of it. People back engineered it, and the general process was going on. Life was going ahead nicely. This was one story that it did not have much benefit. Now you park this story at one gate. Second story. Okay. Second story is a true story. Better. There was a college, the university basically, and in that university there were two friends. The two friends suddenly get an idea of let's have a common platform where people from all over the globe, they'll be able to come together, they'll be able to interact. Even if they're staying in different countries, different time zones, that will not matter, which will be able to at least understand they'll be able to connect. They're able to understand what is going on in each other's life, what is going on in each other's activities you're able to share. This was one concept which they had in mind. Now, as engineers, all of us know that we have to code. If you have to make an application, we'll have to code the application, right? So they went to a third friend. We've got such an idea. We want to build a company around this idea. So firstly, we would like to start with having an app. So will you please be able to start this code the application for you? And then he was like, fine, you can code the app. I'll code and give it to you. You maybe come after a week. I'll do it for you. Can you request everyone if you can switch on your videos? It would be really nice if I can see you, if possible, please.
Hello, ma'am. Sorry to
If
disturb you.
possible.
Hello, ma'am. Can you stop your video so that there is a bandwidth issue is there, I think. If you stop your video.
So I need to stop.
Yeah.
Okay.
Yes, please.
Yeah. So none of others also will be able to start their videos. It won't be possible for them. By any chance, if it is possible for the audience, if they can start their videos.
Yes, I think Urvashi, Sandhya. Please.
Yes, ma'am, they can start if it is required. If there is no bandwidth issue at their end, they can start and both things can work simultaneously. Sir suggested you just because if you face bandwidth issue, then if you stop the video, audio quality will be better.
Okay, so is it now? Is it proper now? The audio quality is okay now?
Yes, it is.
Yeah. So now to continue with our the story. The second story is a true story. The second story says that so the third friend, they go and they said, you come after a week, we will code it for you. And then one fine day, they go after a week with all the ideas in mind. Okay, we'll do this, we'll do that. And then they go after a week. They said, okay, it's not ready yet. I have to do this, I have to do that. You come after another week. They go after another week. And then again, they had some excuse. No, it's not possible. It's not possible, this and that. So he was like, okay, fine. Then what to do? He's like, okay, let me code it and give it to you in 3 days. Like, again, it was not possible, not happening. And then it just removed out from their head, and he also forgot about it. And then after 3 months, they got to know that the two friends, the third friend who was supposed to code the application for the two friends, had established a company on the idea of these two friends. Idea was everything, the initiative of everything, but he knew how to code, so he established a company. So, but that time, whose story is this by any chance? By any chance, whose story is this?
The two friends.
The two friends and the third friend. Whose story is this? It's a true story, by the way. No,
Steve.
no, it's not Steve Jobs. Steve Jobs was a very honest man. Any wild guess? Very famous story this is.
Zuckerberg.
Huh?
Mark Zuckerberg.
Exactly. This is the story of the famous Facebook, Mark Zuckerberg story. And this story, mind you, did not come at that time. And they felt, okay, he must have done. They would have stopped him at that time only when he started with the company. But they did not stop him that time. When the company had grown big and it had millions of worth, that time the story they had removed out. Right? So now we've got two stories. Okay, the point I'm trying to make here, I'm not talking about any individual person, but I'm trying to emphasize on a third aspect of it. So we've got two stories. Okay, so in one story, the inventor was, we can call him as an inventor. He was fearful because it might be stolen, and that is why he did not disclose his invention. In the second story, they were confident, but they went ahead and still disclosed the invention to a very confidential person. They did not go and disclose it in public or something. They went into disclose to a confidential purpose only, also for the purpose of some work or some official purpose. Okay, like they went and disclosed it to a maybe this coder. Sometimes he'll have to have an opportunity. We'll have to disclose the invention to another investor maybe, or we have to disclose it to another vendor. For like in this case, it was some application building or some other vendor. We'll have to disclose the invention, right? But the two friends disclosed the invention, and the invention was being copied. The fear which the first person had, this came true in the second story, right? This is exactly where intellectual property right comes into the picture. This is exactly where intellectual property right brings a bridge between the innovator and the invention being protected. Had the first person protected the invention in some form and then gone to the king or asked the king some kind of alimony amount or something in against disclosing their invention, then it would have been a different story. Had the two friends copied the invention, protected the invention in some form, and then gone to the third friend saying that, okay, this is protected, we know it would work, and then gone to the third friend, the story would have been different. Right? So this is exactly where intellectual property right comes into the picture. So far with me?
Yes, ma'am.
Yes, ma'am.
Okay, thank you. Because I will have to, because we are not seeing each other, I will have to give that, I will need that assurance from you time and again. Till almost 1.5 hours, how much time we are with together. Okay. So this is exactly where intellectual property right will come into the picture. Now I am sharing my screen. Is it shared?
It's coming now.
Is it shared?
It's coming now.
Okay.
Now it has
I hope
shared.
it's done. Yeah.
Yes.
Can someone read the 4 words which is you can see on the screen now?
Innovation, discovery, research, and invention.
Okay. So what is invention as per all of y'all? Like, what do you mean by invention?
Creation.
Okay. Then what is innovation?
Something produced using human intellect.
Then what is invention? What is invention?
The creation which is
Something,
created with
something
something
new,
idea.
new idea.
Okay, someone is saying invention is something which is a new idea.
Madam, invention is something new which has not happened yet, and
Okay.
innovation is the modification or alteration of the existing known system.
Perfect. So invention is anything which has happened for the first time. The first time the television was invented. The first time the computers were invented. The first time the light bulb came into the existence. Right? And innovation, anything which is happening subsequent to the innovation, to the invention, but it is an advanced version. Like we all know, the first computer which was invented was a large machine, right? And now we've got computer which actually fits in our palm. Is it right? Innovation is that. Invention is anything which is new. Innovation is something which is an advanced version or a succeeding advanced version of the invention itself. That is why Philips' tagline is innovation in you, not invention in you. Right? So
Yes, ma'am.
intellectual property right will protect your invention and innovation. This discovery and research, everyone knows it's existing thing. Even before the apple had fallen on Einstein's head, gravity was working. It's not that only after it had fallen gravity started working. No, gravity was working before that also. So anything which is a research or a discovery, that is not kind of protected because it's already there. It's already existing. Okay, but something innovation or invention is something which has the protection. Is this clear to everyone?
Yes, ma'am.
Yeah. Now we come to the actual part of our sessions. Just because we've got limited time, because I know I was given 1.5 hour, but to complete all these topics in a detailed manner, it takes me some more time. So I will not go much deeper, but I will just touch base on each topic and also give you a fair idea. So that at least after this particular session of mine, you'll have a fair idea of what IPR is all about, what are different aspects of IPR, and how do you distinguish between them. Like what is patent, what is trademark, you'll be able to easily identify. And then after this session, I'm sure none of us you'll be able to confuse between a patent and a trademark, patent and a copyright and a trademark, industrial design. I'm sure you won't be able to confuse between any of these aspects, because each of these aspects is a law. So as you see on the screen, innovation will have different aspects. You've got patents, copyright, trademark, designs, technical know-how, trade secrets, domain name. All these are different aspects of intellectual property. Right? In that also, patent, and each of them is a law, by the way. So patent is a law, copyright is a law, trademark is a law, design is a law. Others are just like technology know-how, trade secrets, and domain names. They are all a subdivision. I will have to update that. But these 4 things: patents, copyright, trademark, designs, all of these 4, they are laws, basically. So, and they are governed by each of the specific thing. They are governed by each set of laws which are differing from others. So what patents are protecting, copyright does not protect it. What copyright protects, trademark will not protect it. On a higher regime. Is this clear? So just to make these things more easier for you all to understand, I'll be able to explain you. Like we've got a university, right? So I suppose every one of you all are under Solapur University, the umbrella. Under Solapur University, you've got different colleges. You've got different engineering college, you've got different medical college, you've got different architecture college, arts, science, commerce college, right? So in the same way, and each of the college have different functioning. So what we are teaching in engineering, medical will not be able to teach. What we are teaching in medical, engineering does not teach. What you're teaching engineering, medical, arts and science, commerce does not college teach, right? Am I right? Is it like that only, no? Is it right?
Yes,
Yes, ma'am. Yes, ma'am.
Yes. So in the same way, intellectual property is a bigger umbrella under which you've got copyrights, trademark, trade secrets, designs, industrial designs, and patents, which are the basic, domains where IPR is working about. Okay. Now each of it will be going in detail, and in last 1 hour or so, we will be concentrating more on the patents part. Okay. Patents and patent landscaping, all those part in last 1 hour we will be covering. Okay. What is famous of Nasik? What is famous of Nasik? Huh?
Tula wine.
Sula wines. Okay. What is famous of Kolhapur? Don't say misal.
Kolhapuri chappal. Na?
Chappal. Okay. Paithani sarees are from
Paithan.
Paithan.
Nasik Yeola.
Yes, Yeola. I was expecting this answer. And Banarasi sarees are from
Banaras.
Banaras. Okay. Kanjivaram sarees are from huh? Kanjivaram sarees are from
Kanchipuram.
Kanchipuram. Okay. Now tell me, Kanchipuram sarees, they are from Kanchipuram, then that means they are from anywhere in Andhra Pradesh, south somewhere, right? Yeola Paithani. Okay, Paithani. Paithani, we don't get outside Maharashtra. Huh?
We can
Okay,
get
apples are from.
small one is in Maharashtra.
Okay. How many of you are from Maharashtra here? Proper born and brought up from Maharashtra? Okay. 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 So, Kanchipuram sarees you don't get outside India? We get or we don't get?
Maybe no.
We get Kanchipuram sarees outside India. In US something, it's a bit expensive, but we get. Kolhapur chappals also we get outside India.
Yes, we can get through online.
Yeah, but there are certain stores. There are certain stores outside India where you get these kind of
Yes.
right. That
Yes.
does it mean that okay? Now we think about Kanjivaram sarees. Okay, now Kanjivaram sarees. Okay, forget outside India. Apart from Andhra Pradesh, you can get Kanjivaram sarees in Maharashtra also. No, you get Paithani also in Maharashtra. You get Kanjivaram sarees also in Maharashtra. You get other kind of sarees. Banaras sarees also you get in Maharashtra. So now will I say that Kanjivaram sarees are made in Maharashtra only? Will I say Kanjivaram sarees are made in Maharashtra?
No, we can't say that.
Why?
Ma'am, they are made in Tamil Nadu, but distributed in all over India by
But
online
there
or
are
stores.
certain kind of warehouses which is outside Tamil Nadu, and they do make these saris outside Tamil Nadu also. But there are warehouses, like not official thing, but there are warehouses.
Excuse me, ma'am. Ma'am, about Paithani silk sari, that is renowned handmade only from Maharashtra. That means town of Paithani in Maharashtra. We say that. So it will be available from online platform, offline as well as, and direct from the artisans also. It is globally available, but outside महाराष्ट्र we have to म्हणजे आपल्याला त्याची ऑथेंटिसिटी आणि जी काही क्वालिटी आहे ती गॅरंटेड जी आहे ती इथेच अश्युअर मिळते ना.
अश्युअर मिळेल. म्हणजे महाराष्ट्राच्या बाहेर आता येवला म्हणजे ते नगर भागात येतं, बरोबर? मग सपोज मी लातूरला गेल्यावर ऑथेंटिक येवला भेटेल का? तुम्ही लातूरची
मिळू शकेल मॅम,
येवला
पण
आहे असं
ती
सांगू
त्याची
शकतो का?
ऑथेंटिसिटी
नाही, पण मी असं सांगू
नाही.
शकते का की लातूरची येवला आहे? आय एम नॉट टॉकिंग अबाउट ऑथेंटिसिटी, आय एम टॉकिंग अबाउट द ओरिजिन. तुम्ही असं म्हणू शकेल का की बाबा महाराष्ट्राची येवला आहे?
नाही मॅम, नाही. पैठणची आहे ती ओरिजिनली, तर पैठणीच तिचं नाव त्यामुळेच आलेलं आहे. सो ओरिजिनॅलिटी कव्हर्स अंडर दॅट प्लेस.
अग्रीड. सो ऍपल्स कुठून असतात?
Shimla.
Now we can see apples in Maharashtra also. Sometimes apples are grown seen in South also. They're not authentic apples.
There are a number of varieties are there. त्याच्यामध्ये काही म्हणजे भरपूर हे व्हरायटीज आहेत त्याच्यामध्ये.
The point I'm trying to make here is, all of y'all are right. The point I'm trying to make here is to explain the origin of any agricultural products or agricultural produce or any manufactured product, any good or any product is manufactured that particular geography. Any agricultural group or manufactured products produced in a particular geography. Okay. So geographical indicators. Okay, I'll explain how this geographical indicator actually came into the being. Okay. Now all of y'all are senior people in your profession or been into profession since long. So now tell me, neem, tulsi and turmeric. How long we've been using neem, tulsi and turmeric in our preparations or in our as Indians? How varied use of neem and tulsi and turmeric we've been using in our day-to-day life apart from food? What are the other uses of neem, tulsi and turmeric apart from food, apart from eatables items?
Medicines.
Yes, a very prominent use of neem, tulsi and turmeric even used in medicines. So there was a chemist. Sorry, someone was saying something.
Ma'am, it could be used as an antiseptic also.
Yes. Antiseptic. We can also use it as a cosmetic product. Something we used to use neem, tulsi and turmeric. Why do you have this haldi saman ka asto lagnaच्या आधी for a cosmetic and antiseptic purposes, right? So at least 5,000 years back, we've been using these three items in our thing. As the older the Charak and Samhita is of our ancient Ayurvedic text, at least at that time we've been using. But some years back, there was a chemist, okay, in the US who had made a formulation where he had used neem, tulsi and turmeric as the major formulation to treat cough and cold. Okay, and that time Indian, I think the patent system was not much developed, so he had prepared this formulation and he had patented it and he had got it granted also. Okay, and then Indians like the CSR lab of Indian, they opposed, saying that Are neem tulsi and turmeric we have been using for almost 5,000 years back. How can you give a patent which contains main ingredients as neem tulsi turmeric to a person outside India? He was a non-Indian basically, and this patent was this product was patented in the US basically. So this does not has to go outside India. It's an Indian thing. And there the US government says, hey, we don't have any document. How? Just give us any document which proves. So Indians give a lot of documents from different Ayurvedic documents and everything, and it was being revoked. But then there we got to know that we need certain documents which says that which country, which state is has what specialty basically in terms of agricultural produce or in terms of manufactured goods. What is like this? Like I said, Yeola pattern is only manufactured in Yeola because it is hand woven in Yeola. Banarasi sarees, it's a specialty of Banarasi sarees. It is made only in Banaras because it is hand woven in Banaras. Like Kanjivaram sarees are made only in Kanchipuram because they are hand woven. Hadi, which we say, apples, because they are done only in that particular state. Okay, and that's where there was a documentation work of documenting what is specialization of each country and in each state, and in state also sub districts. Like in Maharashtra only, I can show you. This is the list. Right now I have around 28 to 30, but there are more. These are list only geographical indicators of Maharashtra. It's not anywhere. I have just kind of concentrated on geographical indicators of Maharashtra, which include Solapuri chaddars, right? Solapur chaddars are famous and they are made in Solapur only. Warli paintings, Kolhapur jaggeries, Nagpur oranges, a special type of jawar is grown only in India, only in Maharashtra. There's a particular small village it is. It is grown only in Maharashtra. Okay, everyone knows Mahabaleshwar strawberries, Nashik grapes, everyone knows. But something this I'm showing, which is even Kokam, Ratnagiri Kokam, everyone knows. Ratnagiri Hapus, everyone knows, which is kind of, everyone is worldwide. But a particular types of jawar, a particular type of rice, even Ambe Mohar rice, it is a geographical indicator. And this geographical indicator means it is a property of the state. Not one person kind of holds a right for it. Okay, now, whoever are from Maharashtra, everyone knows Lasangao is onion market basically. So and the red onions which we get, they're from Lasangao. So the red onions are geographical indicators of Lasangao. Also, there is a particular amount of cashew nut, which you say, a particular variety of tur dal. Okay, now you see the 20th content. If you see Jalna sweet orange and Nagpur orange, okay, there's a difference. They are both oranges. Okay, and then you feel Nagpur does not have sweet oranges, yeah? But why is it Jalna sweet orange? Because in Nagpur you get two varieties. One is like if you all know this language, one is a Meetha Bahar and one is a Khatta Bahar. So Jalna has a geographical indicator for Meetha Bahar oranges. Is it clear to everyone?
Yes,
Is it clear? So all this is geographical indicator of particular state. And if you see, Maharashtra has got more amount of agricultural produce than manufactured goods, basically. They said beet custard apple, a variety of custard apple, which is a geographical indicator of Maharashtra. Now you said custard apple kahan se Maharashtra ka hoga? No, there's a variety of custard apple, which is a thing of Maharashtra. Now Sangli raisins. For us, raisins is raisins. म्हणजे मनुके असतात आपल्यासाठी. पण सांगलीचे रेझन्स वेगळे असतात. ना इमॅजिन नाशिकमध्ये ग्रेप्स उगतात आणि सांगलीमध्ये त्याच्या रेझन्स तयार होतात. This is a particular type of brinjal, which is a geographical indicator of Jalgaon. typical Jalgaon brinjal, right? So these are geographical indicators which are property of the state. Okay, and there has been documentation work more which is coming. I've just listed some, but there are more geographical indicators which will be coming in. So geographical indicator clear so far with me? Any questions on geographical indicator? The famous US rice basmati rice dispute was also on this case. Turmeric, it is a University of Mississippi Medical Center case for turmeric, which I spoke, right? Turmeric का वो सबसे बड़ा केस था. Even US basmati, they had got it granted, वहां से उन्होंने revoke किया Indian government ने basmati rice का case. And somehow basmati को GI फिर हम लोग ने initiate किया. Basmati rice is geographical indicator of India. उसमें पंजाब का कहीं से geographical indicator है. So geographical indicator clear? Geographical indicator is a agricultural produce or manufactured goods of a particular geography, of a particular area. Now, इसमें it can either be a manufactured goods or it can be an agricultural produce. You cannot claim anything which is naturally grown there or naturally habitated. Say there is a river which flows from like kind of Maharashtra and goes towards Gujarat. वो तुम्हें geographical indicator नहीं हुई, वो उसका natural flow है river का. जो गुजरात का जो सी है वो नेचुरल, जो geographical indicator नहीं हुआ, वो सी नेचुरल हैबिटेट है उसका. Is it clear?
Yes, ma'am.
Yes, ma'am.
Okay. Okay. Now, all of you all have gone to KFC? Okay. You all must have drank Coca-Cola. Coca-Cola you must have drank.
Yes, ma'am.
What is Coca-Cola?
Aerated drink.
Okay. Then what is slice?
A juice.
Mango juice.
Yes.
Then what is mango? What is fruity?
It is with
What
sour.
is fruity? But it's
Sweet and
mango
sour.
juice only.
Yeah,
It's mango
but
juice only, no? Then what is mangola?
the water content or the liquid fluidity is something that related to it.
Okay. Then what
The
is
percentage of
amras?
water.
Then what is amras?
The amrus is thick, na ma'am. We don't add too much of water in it.
Then what is mango juice?
The water is added. Basically, something like that.
Then what is mango milkshake?
The milk is added.
Okay. So,
Maybe
fruity and slice. Does it fruity, slice and amras? Does it taste the same? It's mango drink only, right?
No, the taste is different.
Taste is different. You said Coca-Cola is carbonated drink. If
Yeah.
I give you carbonated water and if I give you sugar, will you be able to make Coca-Cola?
Might be.
Okay. You might be able. Okay. Okay. You've had mac aloo tikki, you must have had sometime, anytime in the past, or you must still
Yes.
have. उसमें जो sauce होता है, you know what sauce is it? Like what? It's a mustard sauce, it's tomato sauce, or it's the white sauce. What kind of sauce is it? We know na, we have got different sauces. So chili sauce है, कौन सा sauce है?
Mayonnaise and ketchup.
There is a typical yellow sauce there, not mustard sauce by the way. Okay. KFC ka, if people here have visited KFC, and they can see the you can and what spices they used. No. Okay. Now you said Coca-Cola, if I give you carbonated water and if I give you sugar, you might be able to make Coca-Cola. Is it right? How many of you all agree that you might be able to make Coca-Cola?
But the process we can't be able to do.
Okay, so you're saying process you're not be able to do, but if I give you a person from the production cell or the production department, then will you be able to make Coca-Cola?
But the machinery is also, there might be some machinery specifically to use or to prepare the thing.
That if we want to know the perfect
Actually,
formulation of the and that process, we can make. And if that person is working over there, if that person is or he share that with us, so we can prepare that.
You really think the person working there knows the formulation?
It
They know
depends
the
के हाँ
मॅम
one
पेम्बर्टन
yes.
नावाचा कोका तो म्हणजे कोका कोला जे शीतपेय आपण त्याला म्हणतो ना, सॉरी मी मराठीमध्ये बोलतीये.
Yes, yes,
पण
ma'am.
त्याचा पेम्बर्टन नावाचाच एक person
मॅम तुमचा आवाज येत नाही आम्हाला.
सॉरी मॅम दक्षिण
Yes, yes.
अमेरिकेमध्ये काहीतरी कोकाची पाने
Is it the problem only with me or even you all are not being able to hear ma'am's voice?
Yes, same problem here, ma'am. We are not listening her properly.
Ma'am, if it is
सॉरी मॅम
हा
म्हणजे मी जसं वाचलं होतं त्यानुसार की पेम्बर्टनला ते कोका कोलाचं त्याने पहिल्यांदा ते फॉर्म्युलेशन बनवलं होतं. त्याच्यामध्ये त्याने वेगवेगळे कोला नावाचा एक पदार्थाचा अर्क काहीतरी वापरला होता त्यामध्ये आणि मे बी व्हॅनिला आणि असे इतर काहीतरी पदार्थ मिळून त्याने ते शीतपेय पहिल्यांदा तयार केलं होतं असं आणि त्याचं सिरप त्याने बनवलं आणि नंतर त्याचाच एक कॅन्डलर म्हणून एक त्याच्यासोबत असलेले मित्र होते कदाचित त्यांनी मिळून ते कोका कोलाचं नाव असं काहीतरी डिझाईन केलं आणि पुढे ते सिरपच त्यांनी त्याचे हक्क मिळवले आणि नंतर त्यांनी ते विकले असं.
दॅट इज ओके,
कॅन्डलरकडे.
पण मग ते कोकोकोला मध्ये नक्की काय असतं हे त्यांनी सगळं आउटलाईन सांगितलं. बाबा आम्ही फोडणीच्या भातासाठी भात आणि फोडणी एवढं टाकतो, पण फोडणीमध्ये काय टाकतो त्यांनी ते सांगितलं कुठे की आपण फोडणीमध्ये टोमॅटो टाकतो की तूर डाळ टाकतो की चणे डाळ टाकतो की मूग डाळ टाकतो हे त्यांनी सांगितलं का आपल्याला?
नाही
फोडणीमध्ये फक्त भात असतो आणि फोडणी असते एवढं सांगितलं त्यांनी आपल्याला.
हा नाही रिव्हील नाही केलेलं त्यातलं
हा.
ते कंटेंट जे
So my question is ki if I give you a person from their production department, will you be able to make the same formulation of Coca-Cola? Is it possible? Maybe such as hypothetical case we are giving, but is it possible if you meet a person from the production department of Coca-Cola? The production department में उनको पता है ना what ingredients are coming together, how we are working and everything.
Ma'am, the person might know some of the formulation, not the whole or overall formulation.
Okay. Anyone else have their views?
It depend on the post and the वो person
So
कितना
if I give you the
secrecy है you
highest
should
person
know.
in the production department, the highest person in the production department.
नो मॅम.
Maybe is there possibility maybe he should know.
Yes.
नो मॅम नॉट पॉसिबल.
I'll give you one kind of a secret. The recipe of Coca-Cola, not even forget the workers there, not even the top management knows the recipe of Coca-Cola. Proper formulations and वो क्या use होता है कुछ नहीं वो किसी को पता नहीं. It is kept such secreted कि उसको Z+ security दिया हुआ है वो रेसिपी को. And it is opened just 1 in 6 months or once in a year, so that it can be transferred from one place to another place, वो भी in highly Z plus security systems. इतना उसका secrecy है. मैकडी का जो सॉस है ना, now sauces we know, अभी for example if you have to make any, suppose भेल है, भेल वाला हमारे सामने भेल बनता है, वो दिख रहा है ना, वो मुरमुरा डाल रहा है, वो व्हाइट चटनी डाल रहा है, वो ग्रीन चटनी डाल रहा है, फिर वो कुछ मीठा पानी डाल रहा है, we know what he is including, but how he has made that red chutney, how he has made that green chutney, we don't know the ingredients in the chutney. And the मैकडी का people जो सॉस बना रहा है ना, उनको तो ये भी पता नहीं वो रेड चटनी इसकी है, लाइक गुड़ की है या किसी और की चटनी है, रेड चटनी या ग्रीन चटनी में एग्जैक्ट ग्रीन चटनी है, दूसरा कुछ है, उनको वो भी पता नहीं है. दे जस्ट लाइक दिस इज ए बी, कोड नंबर दिया हुआ है, you just have to include that codes together, वो प्रोसेस से दे आप गोइंग, दे डोंट इवन नो, उनको सिर्फ वो एसओपी दिया हुआ है, दिस एसओपी यू हैव टू वर्क, so they don't even know कि क्या किसमें कितना मिस हो रहा है, वो ऑटोमेटिक मेजरमेंट्स दिया हुआ है, इट इज बीन मूविंग. Now, okay, of all the people who are present here, if you all are from IT background or you all know IT system well, whenever we search on Google, right? We search anything that we search on Google search engine, we get some results. Like if you put your college name, you just put Solapur University, you get the entire thing about Solapur University, right? वो सोलापुर यूनिवर्सिटी के बारे में what do you think? What is the engine behind that? Like you put Solapur University, you'll get different results. You put Solapur, you'll get different results. You'll put just Solapur something else, you'll put some different results. You'll get some Solapur Bazaar, you'll get some different results. Why like that? Because the search engine has been built that way. The algorithm is built that way. Even Google ka algorithm is also kept in highly Z plus security systems. It is just removed from one place to another in once in 6 months so that it can be transported. The new codes of Google which comes in. Right? So they are kept in highly Z plus security systems. Why do you think they are kept in such high systems? Why do you think, why is the need of keeping in such high systems? I'll tell you the reason why it is needed. Listerine, everyone must have. Yes. Listerine, everyone have heard? Listerine,
Yes, ma'am.
Okay. What is Listerine? It's a basic mouth freshener. Mouth freshener it is. Right? It's a mouth freshener. It's after brushing, it's a mouth freshener, right?
Yes.
Okay. There was a chemist who had made this formulation for Listerine. Basically, uska naam Listerine it is a trademark which is been given to them. The name was something else. So he had made this particular formulation which had a certain menthol substance in it, some substances which heal your breath or does not, it kind of reduces your bad smell and all that. Okay. So Listerine is for that purposes, basically. And this was the first of its kind. Listerine, when it was invented, was first of its kind. And he had given this Listerine to a third company to manufacture it, basically. And when he gave it to a third person to manufacture it, it was the first of its kind. So, it was kind of, it was it was beaming within people. It was very easier for them. They would have just take one sip or one thing about that liquid, they would gargle it, and they would have had a fresher day as compared to the others. So it was a very welcoming kind of ingredient in that market at those times. So it was a highly demandable substances which was coming in, and because the sale was rising and was really good, but somehow, because it's formulation, right? Somehow the formulation of Listerine, how it is being made, what are the ingredients used, what population, what formulation, how it is made, somehow the process leaked somehow. Okay, it went to the major giants at that time, like Colgate and Pepsodent and all other giants it had gone. And they started making it, they replicated it, and they also kind of replicated it. They made their own copies, they made their own versions and all that, and they bought it in the market. Just because they bought their product in the market, this product ka demand decreased. And because demand decreased, they had agreed that they will give some amount of royalty to the inventor, like say 5%, 10%, 20%, whatever the royalty they would have given to the inventor after their work, basically. And then because the sale decreased, they stopped giving royalty to the inventor. The inventor went to the Delhi High Court saying that it was agreed that we were supposed to pay the royalty, but nothing has happened. So, like we won't be able to, like I'm not getting my pay. So we had actually filed a case in the court against this. And then, okay, he said and then there was a case which had happened, and then it was decided by the court that whatever is the amount it was supposed to be given has to be given, because irrespective of it has to be, it is disclosed or not, it has to be given. Okay. And that's where the clause came in. If the secret or your trade secret of your recipe gets disclosed, the inventor will not get any royalty out. The inventors will not get any royalty out of it. Okay, that is trade secret. So trade secret is what? Any USP of your product which is just kept secreted. A fear of it going outside. So it is something very important to you. At the same time, it is very common. Okay. So once, not common, but it is easy for others to replicate. But it is important. At the same time, it is novel also. So such things are just kept secreted. So what does trade secret cover? It will cover your recipes. It will cover your, any small dearrangement. Sometimes arranging and dearranging a certain way will give you a different results. That is the trade secrets. Okay. Any questions so far? So trade secret is basically, it is just your USP of your product which is just kept secreted. Sometimes we've got in our laboratories, like someone who's from the chemistry background or chemical background, we know, sometimes when you're working in even physics for that matter, when you're working in laboratories, we've got certain results which we get. Sometimes we don't know if this is working or that is working. If this is not working, that is not working. We just write down in our notebooks, in our experimental books, we just write down certain calculations. All those can be a trade secret also. So far with me?
Yes, ma'am.
Yes. Trade secrets clear?
Yes, ma'am.
Geographical indicators clear? Trade secrets clear? Any questions on these two? Any questions on these two?
No, ma'am.
Okay. What is the name of the university who has organized these sessions? Apart from the organizers, I would like to know. What was the name of the college or university who has organized these sessions?
Nagesh Karasgi Orchid College of Engineering, NKOCET. Nagesh Karasgi Orchid College of
Engineering. Okay. You have your logo? College has
Yes,
a
we
logo?
yes, we have.
Now my question is, with your permission, if I take your logo, okay, and keep it for my house, is it allowed?
No, definitely not.
Why? Why it is not allowed?
This is our identity, our branding.
So what if I'm using, I'm making a big hoarding of it and putting it above my house? You'll have your ID cards?
We
College
have.
ID cards you'll have?
Yes, yes, we have.
Yes. Your students are wearing uniform which has the logo, if the students are wearing?
Yes, ma'am.
How are they allowed? वो तो college का identity है ना, तो how are they allowed? Okay, forget me, I'm not a part of the college. Okay? How are you allowed to use? Because you will be saying we are a part of the college. Okay? Now, can you take the logo and keep it on your house? Can you
No,
take the logo? Huh?
no, no.
Why? Why?
The property of college, identity
So,
of college.
then how come you all are wearing the uniforms which has the college logo? How come you are using the letters which are of the college logo? So, like letterhead you're using, na, which has the college logo.
Yes.
Then how come you are using it's college property? Why are you all using it?
Part of that.
Huh? Sorry?
We are a part of that.
That's what my question is. If you are a part of it, you can use the college logo, make a big hoarding and keep it on your house also.
No, professionalism never comes, and I think that logo is a property of a college. It's a branding of the college. So definitely, it must have somewhat, I can say that respect for that purpose.
So I'm not asking you to disrespect the logo, no, when you're putting it on top of your house.
Mm,
I'm just trying to get more things out of you. No? I don't intend anything personal. I'm just trying to get more things out of you. So
yeah, I can
if,
understand.
yes, yes. So how come you are using the logo for in the letterheads? ऐसा अगर आपको वो अगर लोगो को आपको if you don't want to disrespect the logo, you cannot use the logo for your letterheads also.
It is
How
for
are you
market
using the logo for the letter? Sorry?
marketing to spread their institute, such kind of thing,
Name?
something.
Yes. You're closer.
It's the
You should
trademark of
ask
the
me.
college. Yeah.
But
Yes. You
college
should
has the
ask me.
permission not to use it.
Sorry?
No, college is giving permission. College is giving
Yeah.
permission.
Exactly. You're close there. So you should ask me, ma'am, why are you using the logo? If I am using the logo for the promotion of the college, like just imagine like we having these interactive sessions and like we have these FDPs, 5 days FDPs we've been planning. And suppose there is a need that we have to make a big hoarding and we have to marketing about okay, these kind of FDPs are we are holding such FDPs and all that. So we'll have to make a big banner and all that. Suppose if we had to make a big banner, so we would have made a big banner and a big banner we would have put in some billboards or something like that, right? And वो किसी घर के ऊपर अगर billboard होगा तो. But the purpose is for the promotion of the college. The purpose is not my promotion or the purpose is not my individual gains. Right? Whenever you're using a letterhead, are you using a letterhead for your own personal letters or something? Like suppose, for example, there is a student or you've got a faculty of the college, and you're using the letterhead so that you can give that letter to your maybe a neighbor, or you can write that letter and give it to your family members somewhere. Can you use a letterhead for that purpose? No. We can use a letterhead for official purposes, like any assignments, right? Any assignment, or we have to give an official information to someone, official meeting, official thing for on behalf of the college, right? So name, logo, slogans, three-dimensional pictures, sound gestures, all that is called something, is protected under the name of trademark, which is one aspect of intellectual property right. The third aspect, basically, I will say, for intellectual property right. So trademark is basically only trademark is for your name, your logo, for colors, slogans, three-dimensional pictures, sound gestures. Okay. जिंदगी के साथ भी जिंदगी के बाद भी, किसका स्लोगन है?
LIC.
LIC.
Did I mention LIC कभी भी?
No.
Did I mention LIC?
No. But the slogan.
Slogans will matter, no?
Yeah, it is a kind
Just
of
do it.
promotion.
Just do it. Just do it. Just do it किसका है?
Nike.
Just do it.
Nike का है.
Nike. Think different. Think different. Apple. I'm loving it.
McDonald's.
Yes. So even before I say any kind of even if before I say the word, it is that particular, like I'm loving it. अभी I'm loving it, McDonald's में कुछ difference है क्या? मतलब कुछ similarity क्या? Have I mentioned McDonald's name anywhere in it? No. It's an identity of that particular brand. Whenever by eating a thing, I'm loving it, you'll immediately think about McDonald's. Right? Whenever you see blue and white, what do you remember? Blue and white? Blue and white, what do you remember? Okay. I say apple. What is the first thing? Now be honest and tell me, what is the first thing which is coming into your mind when I say apple?
The fruit.
What? Fruit. And
Yeah.
anything, anyone else?
iPhone.
iPhone, iPads. Okay. Except for the first speaker who spoke to me, why did Apple, when I say Apple, iPhone and iPad only came into your mind? Now, which Apple came
Logo.
first? खाने वाला Apple or use करने वाला Apple?
The
Which
edible
Apple
one.
came first? खाने वाला Apple. So why when I said Apple, you mentioned about iPhones and iPads? Is a continuous
Logo.
hammering that brand has done. Yes, features. It's that continuous hammering that brand has done into your heads. Right? And that's where trademark protects. Trademark protects that continuous, that continuity or the continuous brand hammering which the product does on your head. So any name, like you've got the name of your college, that is a trademark. Logo of your college is a trademark. You've got any slogans for your college, that is a trademark. Okay. Cadbury, everyone must have seen or had Cadbury, Dairy Milk.
Yes.
What is the wrapper of Dairy Milk? Cadbury. Color of the wrapper.
The dark purple.
Okay. Now, have you anywhere seen the color of the Cadbury on someone else's brand cover? The purple, the blue color which is there as the wrapper, किसी और के ब्रांड के रैपर में वो देखा है कलर कभी? वो सेम कलर?
No.
Someone is saying yes. Someone is saying yes. किसका देखा है? Which brand has the same wrapping as wrapping with the color of the wrap as the Cadbury, as the Dairy Milk has? Duplicate brands, वो छोड़ दो 2 मिनट के लिए, वो टॉपिक ही नहीं है यहाँ पे. Apart from that, regular brand किसी का देखा हुआ है क्या? Authentic brand का किसका देखा हुआ है? डुप्लीकेट तो फिर वो शाहरुख खान का भी डुप्लीकेट आते हैं, वो थोड़ी ना ओरिजिनल है. No, it's unique, right? Because the color of Dairy Milk wrapper, they have made that color. That wrapper का color उन्होंने वो बनाया हुआ है color. Same way 5-star का color का जो wrapper है, the color of the wrapper is being made. Now 5-star का color and Ferrero Rocher का दोनों golden है. But is it the same?
No.
No. Right? So this is what uniqueness a trademark does to the invention. This is the uniqueness a trademark kind of protects in a branding basically, to be more precise. Okay. So what does trademark protect? It will protect your name. It will protect your logo. It will protect your color. It will protect your shape. There are certain jingles you have for any brand. All those jingles also is being protected by trademark. Clear? Any questions, any suggestions in this? Any queries in this? Any queries in trademark? So trademark will only, as the name suggests, it will only protect a name, logo, numerical, sound, color for a brand name, just the name. Just say, okay, Tata Motors. Tata Motors is being protected by trademark. The logo of Tata is being protected by trademark. The name of your college is being protected by trademark. The logo of your college is being protected by trademark. ना वो पेटेंट से प्रोटेक्ट होगा, ना वो कॉपीराइट से प्रोटेक्ट होगा, ना वो कोई और फॉर्म ऑफ आईपीआर से प्रोटेक्ट होगा. Is it clear?
Yes, ma'am.
Any questions so far?
Ma'am, can trademarks can be used as promotional tools?
Yes.
Promoting.
Very classic examples as trademark using as promotional tools is Dolby Atmos. You must have heard major of our computer systems and your phone systems, theater system, sound system basically has Dolby Atmos.
Yes.
Now somehow the technology behind Dolby Atmos cannot be patented because it's a technical know-how, it is technical, things and all that. So it cannot be patented basically for some reason. What they did is, what technology को उन्होंने नाम दे दिया, Dolby Atmos. Now whenever the technology is going, It is going along with the trade name. So what do you say? Dolby Atmos system is being installed in my system. Dolby Atmos system is being installed in my home theaters. Right?
Yes.
तो ट्रेडमार्क वो होता है कि ताकि उसकी ब्रांडिंग हो, उसको बनाते हैं इसे यूनिक एंड डिजाइनर ताकि उसकी ब्रांडिंग हो. नाउ यू से एप्पल, वो भी आधा कटा हुआ एप्पल, एंड एप्पल एज अ थिंग, वो कैची थिंग, it fits in the mind of the people. Now whenever you see that yellow baba of McD, you immediately know this is McD wala baba. You will not confuse between McD wala baba and KFC wala baba, right? Both the babas are different, isn't it? Both the babas are different. Blue and white of Tata and blue and white of Intel, they are both different.
मी ते म्हटलं काय करू तर माझं कसं होतं तसं तरी यावं लागणार आहे.
Yes, ma'am.
माझं थोडं राहिले 2-3 दिवसात
Someone is switch on their
जेमली जरा भेटून
audio
वगैरे
and they are
बोलून
speaking.
यावं असं माझा विचार होता.
Okay. So this is clear?
Yes, ma'am.
Okay. Okay, this is a question: who can apply for a trademark? Anyone who's the owner of the trademark can apply for a trademark, like owner of this particular company. So either trademark can be applied on an individual basis or trademark can be applied on an institutional basis. That's also. Charges are different, everything is different, but it can be applied. So anyone who is the owner of a particular trademark or who wants to own a particular trademark can apply. And at the same time, anyone who has an institutional based, like for example, in your college, if the logo has to be trademark, it has to be owned by the college. The name of the college will become as an applicant. But if the principal, if the director thinks that it has to be on my name, it can be on his name also. Okay. One very important aspects about trademark. Trademark is always first to use concept. What do you mean by first to use concept? Like suppose, like I'll give you an example of my father. My father owns a milk business. Now he is owning this milk business from the time his father was young. But this is, I think this is the 4th generation that we are using the same business. And we had the same trade name. Now, as everyone knows, during the time of our grandfathers, at least on the time of my grandfathers, the system, India only was not all that developed. It was almost during the time of when Britishers left India. तब की बात है ये. At least go 75-80 years तो हो गए उसी के लिए. Okay. And now they have gone and registered a trademark just a year back. Okay, just a year back, they have gone and registered their trademark. Okay, but because they had all the documents or some proofs of each year from the time of 1979, from 1979 to 2023, उन लोग को जो protection मिला है ना, they have got a protection from 1979. Am I clear? Is this thing clear? So trademark is always first to use concept. So even if you file later on, if you give proofs of the earlier time, from the time you've got the proofs, tab se you can get the protection. Is this statement clear to everyone?
Yes, ma'am.
Okay. So right now, if college wants to file a patent or if any industry wants to file a patent, but they have done work from before, if you give evidences from that time, each year one evidence is some evidences which has the name and the logo in it. The evidence can be as name as something on the website or something on the social media also. That can be also act as an evidence. And once you give that evidence, the trademark can be considered. Trademark clear?
Yes, ma'am.
Yes, ma'am.
Okay. I will not go into details about trademark, but yeah. Now on the screen which you see, the C with the circle. Okay, one more thing about trademark I would like to inform. Is it written here? Okay, whenever you see TM with a circle, like if you have a brand name, or if you're eating any eatables, okay, just check. Like suppose if you're eating a biscuit or maybe hide and seek you're eating, okay, hide and seek के ऊपर just see अगर TM लिखा हुआ है ना, that means the trademark is in process. Like recently, Adidas had lost its trademark. Adidas was not allowed to use the word Adidas, basically. Now imagine Adidas से अगर Adidas ही निकाल दे तो क्या बचा? Question समझ में आया? Adidas से Adidas ही निकाल दिया तो क्या बचा? Do you know who's the owner? Do you know कहाँ से आया? नहीं, हम लोग को सिर्फ ब्रांड नेम पता है. हमको नाइकी पता है, हमको Adidas पता है, हमको रिबॉक पता है, हमको बाकी के ब्रांड पता है. Do you know who's the company owner and कहाँ से आया, कहाँ से नहीं? So Adidas से Adidas का नाम निकाल दिया गया था. And this 10 years, this case was going on Adidas, where the Adidas third company had claimed that the logo of Adidas has been copied from us. That means Adidas का अगर एक logo to मतलब the other company had the Adidas का logo के 3 lines, right? Tilted 3 lines. So 2 lines Adidas had, the other company had. Adidas had just added on 1 line and says this logo belongs to him. So almost for 10 years, this case was going on. At the end, Adidas actually lost that case because the first company says that it creates a confusion in the mind of the audience. It says that, it had said that. And that is why it had lost its trademark. Adidas actually had to go out of the court settlement, had some settlement with the third company and then purchase the trade name. You're understanding the importance of it? That is why I use the sentence Adidas से Adidas ही निकाल गया तो क्या बचा? It's an identity to a brand. It's an identity to a company. And that's why it's important to protect. So anywhere when you see R with a circle, that means trademark is being registered, it is being granted. And whenever you see TM with a circle, that means trademark is in process. There's some litigation out of it, there's some process. It's not yet granted to them. So whenever you're having anything, right from lace to your packets to anything of your household thing, or if you're using anything which has got brand with it, like अगर if you're purchasing any phone, तो phone पे कभी भी देखना अगर नाम लिखा हो तो ऊपर वो लोग को legally allowed है, they are legally supposed to write that trade name and logo for it. Okay. Any questions so far on trademark?
No, ma'am.
Okay. Okay. Wherever you see the C with the circle, where have you seen it? C with the circle.
पब्लिशिंग हाऊस वगैरे.
Yes, publishing house. Anyone else? Anyone else? Books, perfect. Anywhere else? Ubali ma'am, we've got very sincere crowd with us.
Websites.
Websites, perfect. Movie songs, excellent. Anywhere else?
Pictures,
Movies,
paintings.
paintings, yes,
सॉफ्टवेअर आणि डिजिटल कंटेंट.
yes. Miss Sheikh is written पेटेंट, एनी कंटेक्स्ट ऑन दैट? पेटेंट पे कॉपीराइट कभी लिखा नहीं होता है. They don't write copyright in patents. Copyright is a different law, patent is a different law. We'll speak about patent in the next 10 minutes. I will start with patent in the next 10 minutes. Oh, we've already passed 9. Okay, maybe in 10 minutes I'll just wind up with copyright. So anywhere with C with a circle is copyrights.
Some
Okay.
logos के आगे like
हाँ. लोगोस के आगे हमेशा R with a circle होगा या TM with a circle होगा. C with a circle लोगो के आगे कभी नहीं हो सकता. Okay. So anything which has to do with your artistic work, literally any artistic work like painting, cinematography, sound recordings, choreographies, lyrics, informative sessions, exactly, PPTs, whatever, like all of you are faculties, whenever I'm making a PPT and showing it in maybe conferences or even for students, whenever you're showing a PPT, all that is a copyrighted content. You should always write it, copyright, all right reserved, because copyright, once you create, it has been protected. Videos, perfect. Cinematography, artistic work, dramatic work, all is copyright. So anything which has to do with artistic and informative work is being copyrighted. Any questions so far on copyright? Amitabh Bachchan's voice is copyrighted. So basically the entire Bollywood works on copyright infringement works basically. So Amitabh Bachchan's voice is copyrighted. Priyanka Chopra's smile is copyrighted. Sound recordings, cinematographic films, paintings, artistic work, all that is copyrighted. Now we come to the major. So trademark clear, copyright clear. Trademark is for software, computer software. Perfect, Ms. Sheikh, Mr. Sheikh. Copyright clear?
Yes, ma'am.
Yeah. Thank you,
Yes,
Anjali
ma'am.
ma'am. Copyright is for artistic work. Trademark is for
Slogans, name,
slogans,
branding.
name, trade name basically. Okay. Now with full permission of yours, I ask you, whatever you've been heard from me so far, please park that at one place in your mind. Now, जो भी आपने सुना है, समझा है, वो अभी patents में apply नहीं होगा. Now we are talking about patents, the main part of our activity. ये patents में cover नहीं होगा. Okay, वो patents में apply नहीं होता basically. So what is a patent? Now, see, when I'll be covering 5 WS questions of patent. When I say 5 WX questions of patent, I will immediately, you will immediately understand what patent is all about. Okay. Who invented the bulb? Just give me another 15-20 minutes and I'll kind of wind up this session now. I understand it's late for you all, but just give me. I was just of this opinion that I had time till 9:30. Somehow I had that opinion, so that is why yeah. Who invented the bulb?
Thomas
Thomas
Edison.
Edison.
Okay. Which year you remember if he has invented the bulb?
In 80s.
In the early 80s. Okay.
Yes.
Now you really think before 80s किसी ने bulb के बारे में सोचा ही नहीं होगा? And Edison was the only one who thought about the bulb? So,
No.
Professor Supriya is saying, Professor Solkarni ma'am is saying no. So, if no, but when we say Edison, when we say who invented the bulb for the first time, you said Edison. Why? If he was not the first person to work on this concept, why he is considered to be the first one who invented the bulb?
Get patented on his name.
Okay. So, ma'am is saying he had patented on his name. Anyone else? He got first working model. Aditya sir is saying he's got his first working model. Okay. Anyone else? He presented that idea in front of the world. Okay. Anyone else? Vijay sir is saying he's presented that idea in front of the world. Anyone
He
else?
succeeded.
He succeeded. Okay. I'm so sorry to disappoint you all, but all of y'all are wrong. I'm so sorry. All of y'all are wrong. The story of the bulb was the first when he invented the bulb, as all of y'all rightly said, it was in the early 1800 centuries. So the basic principle behind working of the bulb is a conversion of energy, right? We all know energy is never destroyed, it is never created, it's just converted from one form to another form, right? Newton's law, right? So, Dr. Joseph is saying novelty. Yes, you can be partly right, sir, on novelty, but the basic concept behind the working of the bulb was conversion of energy. Okay, so bulb was conversion of chemical energy into electrical energy. And इसके लिए वो bulb glow हो रहा था, वो पूरा दिमाग की बत्ती जल रही थी उससे. Okay, and then, but it was not the first one. In the early 1700th century or in the mid 1700th century, there was a chemist called as Alexander. I somehow don't remember his second name, but Alexander something his name was. He was the first person who was actually successful in creating that model where he could convert the chemical energy into electrical energy and the bulb could glow. Okay. But somehow that model was not, commercially viable. You understand the word commercially viable? Sometimes inventions are novel, it is needed, but sometimes it is not commercially viable. Okay. So the same case was with the bulb. The same case was with the bulb. It was not commercially viable. And then it started with a rat race. How could they make the entire system commercially viable? It's not that the work was not succeeding. They were successful. उनकी भी बत्ती जल रही थी, बल्ब भी जल रहे थे उनके. But they could not make a commercially viable model out of it. And that's where came who? That's where came who?
Thomas Edison.
No, that's where came Joseph Swan, not Joseph Edison. That's where came Joseph Swan, where the present model basically which we have right now, the filament inside, then we have a bulb, a black holder inside, and we've got a frame and all that. All forget the filament, except for the filament, the entire system was Joseph Swan's model. And the black holder which we see below it, actually that was a bit more elongated. Okay, that was bit more elongated. And because it was elongated, why it was elongated? Because for the entire system to work, he had to create a vacuum in that black bulb. Okay, because he had to create a vacuum, that is why it had to make that system elongated. Okay, and still it was not commercially viable. How can you make such a big system? उसको commercially हम viable कैसे बना सकते थे? It was not possible at that time. And that's where the rat race again began. How can you, how can you avoid that black vacuum so that the same work is happening and the same result you can get? And that's where a hero entered whose name was now everyone is quiet. It's like बोलो कि नहीं बोलो
Thomas
कि
Edison.
वापस मैम दूसरा कोई word बोल रही है. And that's where Edison entered. Actually, that's where Edison entered. And he, yes, Nitin sir, yes, and that's where Thomas Edison entered. And he actually, we heard about, of course, he was a great scientist, no doubt. But whatever we heard, he did around 1,500 experiments and 1,000 experiments to identify. And he said, what is not working? What was not working was this. What was not working? वो vacuum में क्या replace करना, that was not working. So he made a filament and somehow he succeeded. And then what filament he used? What was the material that he used in the filament? What is the material of the filament?
Tungsten.
Tungsten. Exactly. So we identified tungsten. So as soon as he identified tungsten, what happened? The need of that vacuum diminished. And the filament was like the जो नीचे का जो part है, it was installed inside that bulb, inside that glass thing. Okay. So as soon as he did that, the system shrinked, basically कम हो गया, space कम हो गया. It was immediately commercially viable. Because it was commercially viable, he was like kind of famous and everything happened. Yeah, they took a patent also on this name. So you are not wrong that he did not take a patent. Yes, he did take a patent on this name. But that time it was all handwritten patents. It was very old times. The computers and all that were not really established. It was all handwritten patents. And that time even, what do you say? Patent procedure was also physical process. You have to give a document and this and that. It was all physical process at that time. Okay. But Edison did not stop there also. He filed an infringement. He filed an infringement case on Joseph Swan, saying that Joseph Swan has copied my invention. Okay. But not everyone knew about this. Joseph Swan also had a patent. And he counter-reflected, saying that it's not me who has filed the patent, it is you who has infringed my patent because the entire design belongs to me. You have just made the filament. You have just removed the vacuum and made a filament, which worked, no doubt, but that design belongs to me. And he proved it with his patent because it was there in his patents. The design, the model, the working, everything was there in his patents. So he proved in his patents. Okay. Now Edison was in a flux. He had the key. Joseph Swan had the lock. And he's lost the case. What he did was, he joined hands with Joseph Swan. And that was the first ever corporation of Edison and Swan, which came into the being for the production of bulbs. Now just imagine if Joseph Swan did not have a patent. Would he be a part of Edison's inventions? No. If Edison did not have a patent, what he did with Joseph Swan, someone else would have done with him. Right? So that's what patent is important. Why you should patent is clear. Now, what do you mean by what is a patent? So patent is basically a legal right which is given by the government to the inventors. For what? For his invention. For a period of 20 years. So a patent is being granted for a patent of is valid for a period of 20 years. What is the original name of Xerox? What is the original name of Xerox? Photocopy. Xerox is the company who made that system of Xeroxing. उसके बाद जो brand name चिपक गया उनमें Xerox ही हो गया. Original Xerox. Technology behind that Xerox was made by the company called as Xerox Inc., which is a US based company. Right? So what is a patent? Why is a patent? You clear? So you have a monopoly for your invention for a period of 20 years from the time of filing. Okay. Who should patent? Anyone who claims to be the inventor for his invention can be the that whom the inventor patent belongs. There are two aspects in it. One is an applicant, one is an inventor. In your case, applicant can be the college. Inventors can be all of the people who have worked on the invention. It can be co-applicant also, it can be co-inventors also. All the inventors in a patent application holds the same weightage, irrespective of whatever. Like in papers, you have a first order, second order, third order, depending upon the serial number. Patent is not like that. Patent, all the inventors have the same right. Is this point very clear to everyone? In patents, all the inventors have the same right. All the inventors, I'm saying. Is this point clear?
Yes, ma'am.
Okay. Then you should patent. You should patent as early as possible, because unlike trademark, you will not get, like, suppose you've made a patent and you found something and you're working on it and you patent it after a year. So unlike trademark, you will not get the protection from all these years until the time you've done it. No. If someone else files a patent before you, even you being the first inventor, first person who's invented it, the rights will go to him, because he was the first person who has filed the patent. Is this thing clear? Is very, very important. When you should file? As soon as possible. But you will tell me, ma'am, my invention is ready nahi hai. I have to have certain test results and all. There are provisions in the patent law. Like how you take admissions, provisional admissions, how do you take in a college? Same way, you can take a provision, you can file a provisional patent application where you disclose your idea. This is what I am working about, this is what I have done. And within a year, you can complete your test results and complete your inventions, and then file a complete specification again within a year. Is this point clear?
Yes, ma'am.
Is this point clear?
Yes, ma'am.
Yes. So within a year, you can still file complete specification. That's why when you should file a patent as early as possible. Don't wait, मेरा ready नहीं है, मेरे पास funds नहीं है, मेरे पास I don't know who to do. We all there to help you all out. But to protect your novelty, to protect your invention, it has to do as soon as possible. Okay. Where you should file a patent? There are 4 offices in India where you can file your patents. If address is in North, you can file a patent in Delhi. If you are based out of South, you can file a patent in Chennai. If it is East, it is Kolkata. West, it is Mumbai. Okay. The procedure to file a patent, I will tell you, very simple. It is like your procedure in your admission system, not in the examination system. What do students do? They learn the subject, they come in the examination hall, they write the subject, the papers go to the respective examination teacher, the examination teacher examines it, comes and gives it to the class teacher, the class teacher distributes it. Okay, and they have any query, the person is passed, fail is been decided on that examination marks. If we have any query, the students can go to the respective teacher and talk to her. Right? The same procedure is in patent office. The inventor does the invention. It approaches a authorized patent agent to draft the application, because patent agents are authorized people. They are experienced people. they have spent all their major part of their career in just understanding the patent regime, the inventions, rules, the novelty and everything. So they understand the invention better, like they understand the drafting better, basically. Inventors will understand. Because unlike papers, patent does not have to be written in just scientific language. It has to be, there's a proper strategy which has to be applied there. Patent has to be written in technical plus legal language. That is why it is called as a techno-legal language. The draft has to be made in techno-legal language, and there is a proper strategy. What should be disclosed, what should not be disclosed, in what amount it should be disclosed, how it should be disclosed, how diplomatically it should be produced. All that thing is there in a patent draft. So a person who is an authorized patent agent, at the same time he understands your domain well. Again, person who can file patents in pharmaceutical, not the same person can file good patents for technical. Is this clear? Okay. Then you draft the application. As per the patent law. Again, how you should be drafting it, how you should be filing it, when you filing it, each and every detailed, whatever I'm talking, I'm just making it a bit simplified, but everything is being properly detailed, segregated in the patent law. Even trademark, whatever I spoke, even copyright, whatever I spoke, all that is being detailed or deliberately it is being articulated in the patent law in a very detailed manner. Okay. So patent, whatever I'm speaking is as per the patent, I've just tried to make it more simplified for the audience as well they connect. Okay. So you draft the application, you file the application in, you can either file the application in whatever, everything is online. You don't have to go physically now and file the application. Everything can be done online. And your authorized patent agents or authorized attorneys are people who can file because they are well versed with the system. They file this thing for you. Second, then, okay, one more very important thing. Then your application gets published.
Ma'am, your voice is breaking. Hello.
Okay now?
Yes, yes. Now it's fine.
Is the voice okay now? Yeah. So I'm saying, whatever I'm saying, here quite very attentive here to me. When application gets filed, your application gets published by the patent office. Now, unlike paper publication, patent publication is a by default activity by the patent office. It's not a ledger, or it is not something which has to be felt proud about. Okay, my application been published. Application publication in a patent publication in a patent law is a by default activity by the patent office. It only means that you have disclose that or you have come, your invention has come into the public forum. It only means that. That does not mean the application has been accepted. That does not mean the application is being granted. Okay. Now, patent publication has got two options. One, you can either expedite the application. So once you file the application, within a month your application can be published. Okay. Second, once you file the application, within 18 months it gets published. So whatever you, if you want to early publication, there's some nominal government fees which has to be paid, but application can be published. Okay. Then you have to file something called as a request for examination, where you have to request the examiner to examine your application. Again, that can be expedited and also that has a normal route. Once you file the request for examination, then only application gets examined. Otherwise, once you don't file request for examination, application does not get examined. Please have this very clear, because I get a lot of questions from mentor कि मैम मेरा अभी examination नहीं आया, मेरा examination नहीं आया, but then we get to know the examination request was only not filed. Okay, the examination report has to be filed within a specified period after the filing. Otherwise, still your application gets abandoned if you don't file request for examination. Then that application will be examined by the controller. If he has any query, he will get back to you in the first examination report. You reply to him, and still you reply, and still if he feels that there is some kind of small thing which I need to discuss, then he apply. Then he states for a hearing. He asks for a hearing. In that hearing, you can, there is actually now hearings are also one-to-one. So you can also talk to the inventor one-to-one, discuss your invention, also discuss about the objection that he has raised, give your arguments against it, and then he decides.
Hello.
Sir, I
Hello,
think
Kalyan.
madam left.
I think she has left. I think got
We got
disconnected.
disconnected, yes.
Yes, yes. Ubale ma'am.
Yes, sir.
Yes.
I'll check this with.
Okay.
Maybe there's some. Is it audible now?
Is it audible?
Yes.
Is it audible now?
Yes,
Yes,
yes.
Yes, ma'am.
Yes. Somehow I was just gone out of it, like because I had left. Okay, so almost I'm done with it. So it gets examined. Now again, there are three criteria for a patent to be patented, for an invention to be patented. First, it should be novel. Second, it should not be obvious. That means it should have an inventive step. Novel means what? It has to have some innovative content in it. It is your inputs in the invention, basically. Right? It is your input in the invention. Second, it does not have to be obvious means what? Whatever inventions you are doing, it does not have to be common for a person in the same domain. Okay. And third, it should have some application. These three criteria are the only criteria in which the application has been examined. It is also, we also check if it has got a prior art or no. All those things have been checked only when the application has novelty or no. Any questions so far on this?
No, ma'am.
Ma'am, hello, ma'am.
Yes, sir.
How many days required after filing the examination
For
of my
what?
patent? I
For
have
what? For granting or publication, or for what?
for hearing or publication.
For publication, if you have filed for an early publication, so within a month your application gets published online. And for
No,
hearing
already.
and everything.
Already I have published last month. Now I am waiting for hearing. So after filing, how many days we are waiting?
No, actually what happens is after they file, the application
Yes.
goes to the patent office. Generally, as
Okay.
per the patent law, within 3 months to 6 months, they should share the examination report. But presently, they take a lot of time because there is a lot of manpower issues, or there is some kind of technical issues with the patent office. So they take time to reply back with the examination report, but they do reply back. If not, will never happen that they've sat on it and they're not working. They will get back, but somehow it takes time. But I will always recommend it if you go for an expedited mode of application.
Okay. Thank you.
Nitin sir is saying for how many years a patent is held by the owner? For a period of 20 years. For a period of 20 years, but that will start from the time of your filing. Okay. But 20 years will start from a time of filing. Okay. Bhupendra sir is want to has a question. Sir, you can unmute and ask your question.
Good evening, ma'am.
Good evening, sir.
Ma'am, what are the challenges one can face if he or she can file patent without the help of any patent agent? And what he should be taking care of while filing patent?
Okay. Bhupendra sir, very important question that you have asked. I'm not saying that you cannot file a patent without a patent agent. If you are well versed with the patent drafting language and if you are well versed with the patent law, you can please go ahead and file your draft. If you are very well, I have also seen a lot of inventors whom I have taught them drafting and they have gone ahead and filed the drafting. So what you need to keep in mind is the draft. Basically, draft is such an important thing. So till the time you are hearing, you're not in one-to-one with the examiner. So all your invention, everything is being conveyed to the examiner through your draft only. And again, patent law has a requirement that draft has to be as per the patent law. So there are certain do's and don'ts in the patent law which has to be followed. And again, it has to be followed strategically. It's not just, just a copy paste of it. What is written here, we need to do this. No. There is a strategy of how, and again, in a draft, what is important is your claim. Claim writing is the heart of your draft. Like others can still be manipulated. It can be written in a different form to support your invention. But the main thing which conveys about your invention is your claims. And in that, there is a certain restriction that there is an independent claim, there is a dependent claim, there are supporting claims. Okay, all those aspects are there in a claim writing. So it has to follow that law. Like what I'm trying to tell you is your draft has to follow the law. At the same time, it also has to convey the message. At the same time, it also does not has to give unnecessary information. This is a point that you have to keep in mind. So if you're well versed doing it, you can please go ahead. Second possibility is whenever there's an so you draft the application. Okay, when you get an FER, so filing sabka filing accept hota hai. But whenever you get an FER, again, how do you reply to that FER? How do you give that that difference? How do you convey that difference? And the difference is not just about the technical difference. Sometimes there are also formal requirements or formal objections which is being presented by the patent office. So you have to amend your draft again. Sometimes you have to amend your claims again. Sometimes you have to amend the entire draft again. Sometimes you have to amend your entire drawings again. Again, drawings hota hai to वापस description भी change hota hai. So a lot of amendments has to be done. So, and that again amendments has to be in line with the draft which is present. तो आप ये नहीं बोल सकते अरे वो draft में वो I'll just give you a small example. Like suppose in your draft you have mentioned about one element in a very minute way, or maybe you feel that it was not all that important, so you've not mentioned it in your draft. Okay, but somehow वो FER में आपको ऐसा लगा कि अभी ये तो mention करना पड़ेगा. But you cannot mention that element because you've not mentioned it in the draft. Because in the hearing, the examiner will ask you, where is this reference in your complete specification? So your complete specification is a very important document which will hold all through your patent application.
Ma'am, in addition to this, one supplementary question was there.
Yes,
Can you suggest some useful web sources for preparing patent agent and trademark agent examination?
examination. So there are no website sources. All that you need to do is just understand the patent law very well and connect with it. At the same time, you need to understand the drafting well. You need to read different patent laws. You need to read different patents which has been already granted, and then get an idea about it and draft. There are no website as such where you can. There are certain people or certain patent agents who take their classes for patent agents and trademark agents. Not trademark agents, but patent agents. There are certain attorneys who take those classes. So maybe you can inquire with them.
Okay, thank you, ma'am. Thank you so much.
Yes. Any other question?
Hello, ma'am.
Yes, sir.
Ma'am, we have seen some of the patent they grant somewhat early, 1 or 2 years, but some of the patent they take 5 years, 6 years, 7 years. So this period depends upon what, and up to what period we should be waiting, because once you put a patent, we cannot go for a publication also, right? So if we are waiting for 7-8 years, then up to what time we should wait?
Okay. So now to answer this question, first of all, patent, once you file, you can go for a publication. You need not wait for the patent to be granted to go in for the publication. This is the first question, and to answer the first question. Second, I have mentioned about this term called as expedited examination. What do you mean by expedited examination? Where you're asking the examiner to expedite your examination process, basically. Okay, but there are also criteria who can apply for an expedited examination. If any one of the inventors is a female, like you've got 4-5 inventors, any one of the inventors are female. Second, it should be a startup. Applicant should be a startup. Or third, the applicant should be a government or the state or central government institute. Fourth, the application should have filed a PCT application outside India. In either of these 4 cases, you can file an expedited examination. So when you file an expedited examination, within a year, you see the examination report comes in. And we have also seen within a year, the application is also getting granted. Within 1.5 year, application gets granted.
Okay, but naturally also there is a difference. Some of the patent they granted within 1 year, some of them taking 5-6 years. Why this period
Yes,
varies?
sir. Again, expedited examination, normal examination ka difference is. Second difference is about what do you say? Domains, different domains. Who's the controller?
Okay.
And third, it is at a discretion of the patent office.
Okay. Okay.
Ma'am.
Thank you, ma'am.
Yes, sir.
Hello.
Yes, sir.
Madam, can I add one thing in this particular question asked by the sir?
Yes, sir.
Actually, that period, as you said rightly, that depends upon which category. But if the first name of the applicant is female, then that process is faster. If the first name has to be a female name, and
Not first
secondly,
name. Not first name. Sir, not first name. In the inventor, as I said, all the inventors in the patent application holds the same right. So even if anyone's name is in the second last number or third last number, that will not make a difference, first of all. In the inventor list, any one inventor can be a female, should be a female. In that case, you can file for an expedited examination.
And secondly, ma'am, the period, as he said, if it is a design patent, then the period is less. But if it is a utility patent, then it takes a time. As sir was asking, it takes 6 to 7 years for granting a patent if it is a utility patent. But if it is a design patent, then it will be granted earlier, maybe even 7 to 8 months also.
Yes, sir. Design patent is basically it is a aesthetic appearance patent. Like for example, I have this case. Okay. Now, the way the case is, the shape of the case, like if you see there is a design here. Okay, this again is a thing. There's something written. Forget this written. You can the shape here. You can again see this oval shape here. You can see this shape. You can see the back structure here, right? The aesthetic appearance of a product can be a design patent. But if you have to go into the details of it, like tomorrow, instead of this rectangle, I can make it vertical also. So aesthetic appearance of a patent can be a design patent. Okay. But the technical aspects of your invention has to have a utility patent. So design patent is also a different patent law, and utility patent is also a different patent law. Both are patents, but those are different subsets basically. So design patent is only for aesthetic appearance, and utility patent is for a technical perspective, like the technical insight. Like for example, I have this case. Only the outer appearance, how the look of it, not even the feel, how the look it is, how it is looking, वो होगा design patent. But the material used, the ergonomics used for this thing, ये hinge जो होता है वो कैसे work किया हुआ है, कैसे connect किया हुआ है, how it is moving, मतलब sometimes there are some cases जो इसका ऐसा 360 भी turn होता है ऐसा पूरा, how it is working, all that the agronomical base is a patent. वो design cover नहीं करेगा. Design सिर्फ aesthetic appearance cover करेगा. Okay, so sometimes in our
Thank
patent
you.
application, what we do, we give a combination of design plus patent. So we go with the design application. At the same time, we also parallelly proceed with the country specification.
So thank you, ma'am. Thank you, Kalyani
Yes.
ma'am, for an engaging and interesting session throughout this talk. Your insights into the patent landscape have provided us with valuable perspective and a practical knowledge. Before we move for the vote of thanks, we have two announcements for the participants. All participants are requested to go through the ATAL platform and check your attendance. Yesterday's attendance, you need to check. You need to go through your ATAL FDP platform and check your attendance. And today's feedback link is shared in a chat box. All are requested to submit your feedbacks, and the link will be open tomorrow 10 a.m. in the morning. And the link is also shared on the WhatsApp group. So let us propose the vote of thanks for today's session. As we conclude this session, I would like to extend our heartfelt thanks to Ms. Kalyani ma'am for her time, expertise, and wisdom. Your guidance has enriched our understanding and inspired us to think more innovatively about the intellectual property and its commercialization. A special thank you to all the participants for their active engagement and curiosity, which have made this session both interactive and successful. Let us carry the knowledge gained today as we continue our journey towards innovation and excellence. Thank you and have a wonderful evening ahead. On behalf of Orchid College of Engineering and Technology and from ATAL FDP, I declare that today's session is over. See you tomorrow for day 3 at 6 p.m. In the evening. So thank you from our side. And thank you, ma'am,
so much,
once
sir,
again
for having
for
me
your time.
invited here. Yes, sir. Thank you so much for having me invited here. I'm sorry if I've gone a bit out of schedule because of the technical glitches which we have. But if any one of you all if wants to connect with me or anything, my address and my email ID is also there with the organizer. At the same time, it's also been displayed on the screen. And if you have any questions, any queries, maybe you can also mail me regarding this, and I can cater to all the questions mentioned.
Sure, ma'am. Thank you. Thank you for once again on behalf of our organizing team. Thank you.
Thank you, sir.
Yes.
Sir, if I can get the feedbacks of the audience also in my mail ID or something, it would help me to.
Sure, ma'am. We'll definitely get the feedback from the audience and the participants.
You can share the feedback.
Yes, thank you. Thank you.
Yes. One more thing, ma'am. What?
Yes, sir. Yes.
Hello.
Yes, ma'am.
We are putting all this session in YouTube. So, is there any problem with you if I put all this session on your YouTube?
No problem, ma'am. No problem.
Okay, fine. Thank you, ma'am.
Madam, can I get the PPT notes?
PPT is there with ma'am. If possible, maybe you can share. You can have the PPT.
But I will display in ATAL portal after completion of FDP. You can see through your login in ATAL portal.